It's attorney to come, but page 4, the very last person on page 4. Apparently we just turned 15 CPS workers here. She's saying that they have admitted him.
Okay, is it Jose Perez? Okay,
So,
well, can we have the come up? Yeah. Megan, can I see you for a moment?
and I let Norma know.
Reyes?
All right, if you'll call Joanne Eckel.
Just you.
Mhm.
Thank you.
Oh, don't worry.
Dominguez, well, he's on page 40. Yeah, he just. Yes.
Oh my gosh. It is so beautiful. Thank you. You know, I love my magnolias. Oh my gosh, it smells divine.
It does, doesn't it?
My magnolia hasn't come in bloom yet.
Ours started this weekend.
Yeah.
You could tell, you know, they were swelling up.
Yeah.
And then suddenly yesterday morning, they just popped.
It smells awesome.
So,
Thank you.
and enough of them were down below that I could get one.
Which, yeah. I love this in gardenias. When you have this in the backyard, this gardenias and wisteria, it's just like
Oh, gosh, yeah.
divine.
My wife's gardenias are going nuts this year.
Oh, wow. I just put some down because I did my yard. I took up all the grass and I just have fruit trees and flowering plants. Oh, that smells.
That's personal, you know. I go out, what my wife refers to as I go out and I commune with my grass. When I'm watering it.
Yeah.
Happy spring.
Oh, thank you. Happy spring to you. All right. Vashawn, on Jose Perez and Megan, we're going to reset that. Norma, reset that for July 7th.
Yeah, no,
Who's next?
yes, ma'am. I have, Jose, one second dance.
Jose, I'm sorry, Jesus Suarez Moreno. Everyone, you're not at the family reunion after a funeral, after a Black funeral. We are in court. So lower your voices. Megan, you know what I mean. Vashon, you know what I mean. Every Black funeral becomes a family reunion. We're not doing that today, people. All right. So he's scheduled for jury trial.
Great.
All righty. You all are being recalled for Wednesday. We'll see if this trial concludes today.
Tomorrow morning?
Yes.
Thank you, Jim.
Norm, if he can have a reset for tomorrow. All right, who's next? And Phyllis, are you guys trying this together? Phyllis, are you guys trying this together? All right, so if y'all want to, if you want to call in, I would say by 3 tomorrow, not 3 tomorrow, 3 today,
Okay.
I'll know what's happening with this trial. Well, let's make it 4. I'm sorry. Because we're not starting till 1. I don't know if they're going to end up working it out or anything.
Okay.
So just call and then you all have contact with your client?
Yeah.
And then I'll let you all know if y'all need to come in tomorrow.
Okay,
All
thanks.
right, thanks.
Oh, that. I love stuff.
Who's next?
Isidro Sanchez on page 9, second down.
Isidro Sanchez.
Good morning.
Good morning. All right, have you received all discovery?
I believe so.
Has an offer been tendered?
Yes.
Not.
How old are you?
What can you be?
33. Norma, I need a reset date in 3 weeks for plea deadline date. All right, May 5th.
May 5th. Thank you.
Yes, once you sign the reset form, you're excused.
Thank you.
Hello? Mm-hmm. Hello? Norma, do you have an ETA for them? Who's next?
Yes, ma'am. I have Nicholas Gonzalez, page 1. That's where.
Nicholas Gonzalez.
Morning, Your Honor.
Morning. All right, do you have all discovery?
So we don't, Your Honor, there seems to be some sort of glitch. We filed our notice of appearance. The notice of appearance shows up on the.
All right,
court.
so where are we on discovery?
We don't have any, and they've uploaded it, but we can't see it.
So I was gonna make a copy on a disk for him to pick up to review, while we try to figure out why it's not transitioning.
All right, Ms. Ferguson, I need a 30-day make this a 45-day reset for discovery. Okay. All right, June 15th, and state at that time you need to be prepared to tender an offer.
Absolutely.
All right, thank you.
Thank you, Your Honor.
Thank you. Once you sign the reset form, you're excused.
Yeah.
Judge, you want me to step in the hall?
Oh, yeah. Hello. Yeah, I love IT. Okay, so it keeps saying it's connecting to audio.
Yeah.
IT, you are fabulous. You come down here to solve problems that don't exist, and I think it does because of what it's saying.
It's started.
So it's like a scam, but don't join. All right. Thank you. Oh,
Good morning, Mayor.
morning.
For a moment.
How's it going?
I'm doing well. I'm in trial.
Oh,
I'm
okay.
226. I start up at 10:30. I got a motion here. The state's not objecting. It's not on docket, and I know the court has those issues. It's a motion to travel. We're requesting that if the
Oh, do
court,
you have the motion?
yes, I do. And if the court, on the order, the state just said that they're not opposing. It's the last page.
Okay.
He's leaving on the 23rd and coming back on the 27th. I'm
Okay.
requesting that the court, he's going to be giving his itinerary, which is attached to the motion to
Is he
pretrial.
on probation?
No, it's a pretrial services. He's on bond. And that when he returns within 24 hours that he's sent to a UA.
Okay. Let
Just
me
my
just-
standard practice is always to request a UA within 24 hours and given an itinerary to
No.
either the court or to pretrial services, whoever's involved.
Okay, and just do a copy of that so you'll have it and I'll put it in the system.
I appreciate you
All
most
right.
greatly. Be safe.
I love it. I'm loving the outfit.
I'm in trial and this is trial mode.
Hey,
It's trial mode. You got to look powerful.
oh yeah.
Thank
Well,
you,
good
Judge.
luck. Thank
I
you.
appreciate you.
You're welcome.
Thank you, ladies. You have a wonderful day. Be safe. Judge, may I exit through this back door?
Yes.
Thank you.
All right, who else is ready?
I'll check back.
Veronica Callahan? All right, this is the PSI. Attorneys, when you approach the clerk, you need to let them know the reason for your approach. So they'll know what documents I need. You don't have to file stamp it. That's okay. All right, the court is calling 2025 CR 0085561, State versus Veronica Callahan. Can I have parties announced?
Lauren Espinoza for the state.
Matthew Allen for Miss Callahan.
And are you Miss Callahan?
Yes, ma'am.
All right. You entered a plea on January 27th. According to your plea, the state was proceeding on count one, waiving the enhancements. Punishment is to be assessed at a cap of 6 years in the prison. There's a $1,200 fine. The state is opposed to your application. They're taking in consideration 2025 CR 014278. Have both parties had a chance to review the PSI and TAP evaluation?
Yes, Judge.
Yes, Your Honor.
Are there any objections?
None from the state, Your Honor.
No, Your Honor.
Any objections to the court reviewing the PSI and TAP evaluation?
No, Your Honor.
No, Judge, sorry.
All right, and state you're opposed. Do you have any witnesses?
No, Your Honor, just briefly.
Defense, do you have any witnesses?
No, Your Honor. Just argument as well.
Right, just give me a moment. All right. State, you may proceed.
Your Honor, we ask that you deny Ms. Callahan's applications and sentence to a cap of 6 years in the prison. Ms. Callahan has criminal history. She's been convicted of 2 DWIs, a manufacture and delivery of a controlled substance, PG1, as well as the possession of a controlled substance, PG1, 4 to 200 grams, as well as another possession in 2016. Of these cases, she's been granted probation in 4 of these, 3 of which she was granted probation resulted in motions to revoke and sentencing either into the respective Bear County Jail or TDC. Ms. Callahan has been given chances on these probations and ultimately cannot comport her behavior to comply with the rules and conditions laid out before her. Based on the PSI and TAP, Ms. Callahan's in the pre-contemplation stage. We can see her when she recounts the facts of this underlying case. She essentially blames the officer. She said that she drove away because he reached his hand inside of her vehicle without providing a reason for the stop. However, she was afforded that explanation that it was because of expired registration. It was only because of her action of not cooperating with turning over her ID and identifying herself that the officer attempted to open the door to assist her out of the vehicle for non-compliance. She then drove off, and it was only after her vehicle was spiked, the rear tires had blown out, and there were multiple patrol units following, both marked and unmarked, that Miss Callahan stopped. Once she stopped, she still did not comply. She refused to get out of the vehicle and had to be assisted out by officers. Your Honor, Miss Callahan alleges that she has ceased majority of her drug usage throughout her life. However, I think it's perplexing that she expects the court or asks the court to believe that she has no usage. She merely just possesses narcotics. So because of these reasons, Judge, we'd ask that you deny her applications and sentence to a cap of 6 years.
Yes, Your Honor. The criminal history is what it is. So she was on parole. She completed that. As far as the instant offense, it's not a drug case. It's an evading arrest case. Her recitation of the facts are just that. It's a recitation. It doesn't say I'm not guilty of evading arrest because the officer reached into the vehicle. It's just her recounting what happened. Obviously, she's here because she's taking responsibility. She called the police even when she was driving, and we've had multiple conversations. 1, you can't take off when a police officer is there. 2, if you did, when you call the police and there's multiple other officers there, you pull off to the side of the road. You don't get to choose where you stop. And she understands that. She understands that, takes responsibility. That's why she's here today. She's not saying I didn't evade arrest or that there was some legal reason why I was able to not comply with the officer's commands. And that's why she's here, because she took a plea to accept responsibility. Since she's been out now, as far as the PSI goes, it says here current address. She actually does now have a stable address here in San Antonio, Texas. So she's not homeless, which helps with obviously trying
Why
to.
didn't you pull over?
The reason she didn't pull over is because she didn't feel that the officer explained anything. She thought she just got pulled over, and then he was reaching his hands into the vehicle. She felt unsafe. That's why she left and called the police herself.
So why did they have to put spikes down?
Again, that's because she was then trying to say, well, she was going to feel safe if she went to her house. So she's not driving at a high rate of speed, but we've had that conversation before. And so something from probation would be like a cognitive course, and thinking and critical decision making, because obviously that's an error in judgment. And that's a mistake. That's why she's here. As far as she does have a stable home, she actually has 2 jobs. One is a home healthcare worker, and I know the court sometimes does not allow people, but she has another job where she helps remodel a business for a man named James. She provided a letter from him to probation as well. So we have talked about this court and home healthcare working, and that's why she has another job set up and is already working that. Like I said, her housing, she actually had a trailer where she paid an individual $4,000 to live there. Well, that individual is not there any longer, and his wife is not agreeing with that. So she lost out on that money, but again, she's found other places. Mental health, She had been diagnosed a long time ago with manic depressant and bipolar. Again, she is working. She has support here. Paul Dickens is here in the courtroom, and he shows up. She showed up to court yesterday because she's heard this court say, do not show up late. She showed up a day early. She takes this case seriously. I don't see how sending her to prison sends any message or helps anybody. Again, she can take drug tests, she can work, she has housing, she can take a cognitive course, she can do a mental health evaluation. She even explained about that some of these things during the interview, she was crying because it was bringing up past things. And so she tried to be open and honest about it, about her past. And so again, they cognitive behavioral therapy. Again, there's some adverse childhood experiences. She has had a pretty good childhood. I just think that the court can put conditions in place that allows Miss Callahan to continue to support herself, get better, and protect the community all at once. And so we're asking this court to give Miss Callahan just an opportunity to go on probation. I understand she had been on probation a while back and didn't take advantage of that. But she is a different individual here today. She wants to take responsibility. She does want to show the court and herself and her support system that she can follow this court's orders.
May I answer the question
About
the reason of,
Do y'all need to step back?
well, when that's the child, his supervisor. The reason being was that he was.
Yeah, so she had conversations with the supervisor of SAPD about the interaction and some of the ways that were done. And so, but again, that's after the fact. That doesn't absolve her from it, but she has tried to take responsibility, examine herself and her responsibility in that situation. And obviously she was wrong, and that's why she's here today.
State.
Your Honor, I would just ask the court to deny applications. Ms. Callahan told, when asked how supervision would help her first statement was, it would definitely help me so I don't lose my freedom. I think that's what is exhibited here. Ms. Callahan thinks her freedom is more important than the law. She thinks that she can flee because she feels unsafe. And at what point are we to show Ms. Callahan that you must comport and comply, and you can't keep running from things because you think you're right? So I don't believe she would be a good applicant or candidate for any sort of probation judge. And while this court may and will probably be able to accommodate and target some of the issues Ms. Callahan experiences, I don't think she is deserving of that chance because she's shown she cannot comply.
All right. Anything you wish to say? I mean, if you want to say something, then I'll have to put you under oath. State will have a chance to ask questions.
I just know that.
All right, no.
No,
Do you want,
I don't want to.
Okay. No, Your Honor.
you're sure? Ms. Callahan, what I'm telling you, if there's something you want to say to me, then what I have to do is I have to swear you in. And then I will listen to whatever you want to say to me, but the state will have an opportunity to ask you questions as well. So do you need to speak with her concerning that, counsel?
No, Your Honor, we've spoken about it. And no, she doesn't wish to talk other than what I've explained and what she's said.
All right, Ms. Callahan, I reviewed the PSI, the TAP evaluation. I've listened to your attorney and listened to the state. I just don't think you're a good candidate for probation. Okay. I'm going to find you guilty, taking consideration 2025 CR 014278. There's a $1,200 fine, time and money run concurrent. I request the therapeutic community, and I'll sentence you to 3 years in the prison and give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Right to Appeal with your attorney? Did you understand it and sign it? because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. All right, good luck to you. Who's next? Justin Bettis. Oh,
My name, my last name, if you pronounce it correct.
oh, how, is it Bettis? Thank you. I try. All right, on this case, where are we on discovery?
It does, what the discovery's complete, Judge, I just want to, right?
Yes,
Yes,
okay.
yes, Judge, sorry about that.
So, and does there need to be evaluation?
No, Judge, I think we have a plea agreement. I would like to see if we could request it recalled tomorrow. I am getting called over in civil district court for a hearing that what has been set for a few months now. So they're killing me. And I also need to verify that Haven for Hope will accept him back. And he's given me his case manager, and I can get that done today and be ready to go tomorrow if we can recall him for tomorrow.
All right, and do y'all think he will be appropriate for mental health court?
I don't think mental health is an issue, Judge. I do think the TAP eval as a part of probation will be good because I think he's struggled with alcohol. And this was directly related to.
Right, and on the civil side, who is your hearing with?
I'm sorry.
On the civil side, who's the judge?
It hasn't been assigned yet because Matt Saucy on the opposing counsel. He has marked us conferring and we're waiting to get assigned as soon as I can get over there.
Okay, well, if you all do the plea now, I'll take it up. That way we can get him where he needs to be as quickly as possible.
Okay, that would be fine.
All right, so.
I'll let him know. I'll let
yes,
my,
and I will take you all up as soon as you've
Okay.
done the plea. You can
Thank
skip
you.
in line.
okay, perfect.
Thank you.
Thank you.
All right, who's next?
Yes, I have a peacock, page 3, 5 down.
Billy Max Peacock. Billy Peacock.
He's not here.
All right, if you'll come forward. Deputy, if you could make an announcement for Billy Max Peacock III, please. Court is calling 2026 CR 0027445 State versus Billy Max Peacock III for the state defense.
Matt Stolhansky for Mr. Peacock.
All right, this hearing was scheduled at 9 a.m. It is now 9:51 a.m. The defendant has not answered the docket. Deputy, did you make an announcement?
Yes, Judge.
And what were the results?
He-
All right, defense, have you had any contact?
Not this week. I've spoke to him before, but his phone number's been disconnected and my alternate contact number is not working, so.
All right, state.
You look like the bond forfeiture, Your Honor.
All right, the court will issue a judge's warrant, remand your client without bond.
Yes, ma'am.
Thank you.
There you go.
Yes.
Thank you.
Who's next?
Stephen Limon, page 5 down.
Stephen Lamone.
Yes, Your Honor.
All right, where are we on discovery?
Discovery looks sufficient, Judge, at this time. I know this is early on in the settings of of the new case, but we wanted to see if the court would allow referral for felony drug court. This is an individual that has demonstrated some treatment needs, and we want to see about potential options so we can hopefully dispose of the case while also getting him treatment.
So are you all planning on entering a plea and then?
So he's on probation, Judge, for a DWI case.
Mhm.
He also has a newly indicted DWI case, which I believe we can see the concern for treatment, Judge. He was granted probation and set to meet with a felony veteran treatment court. We called them earlier this week to see if there's any avenues that they would keep a spot open. They
Mhm.
said, unfortunately, at this time, they're at capacity. But he was let out of custody and he had to make an appointment with them. He missed that crucial appointment, and at which time after that, a warrant went out, Judge. So we're asking for one final referral of this court for possible felony drug court to see if Judge Glenn has some ideas for treatment options, which if it includes inpatient, my client is willing to undergo that as well.
What do you want to call over to felony drug court, or if you would like me to send them an email to see if they even have any openings?
Okay. Yes, Judge, that's not a problem. I
right.
can contact Ms. Zamarron.
All right, if you want to call and see if they even have any openings, because if they don't, then
Understood. Yes.
Okay.
Yes, Judge. Can we
Yes.
heard on this matter once I've
Sure.
done that? Okay, you can take this.
all right, who's next? Here's Jones, page 6.
You can come up to.
Pierce Jones.
Yes, yes. This is also mine.
Okay. Is this an MTR?
No, Judge, it's a regular case. It is older because of some competency issues. She was at the state hospital for a couple of years.
So then what I'll do is, since there were competency issues and he's currently competent,
He's currently competent, Judge, that's correct.
all right, I'm gonna do this for a quick turnaround for a jury trial and plea deadline date.
Of course, Judge, yes.
Yes. Do you have all discovery?
The discovery, Judge, there is a lot of it. I was talking with the state about that. This is a first setting since been thrown from the magistrate courts. I was just gonna request a short recess of 2-3 weeks.
Okay,
And I believe that there may be an affidavit that they're complaining with.
all right, Ms. Ferguson, I need a 3-week reset. All right, May 5th. All right, we'll be back on May 5th, okay?
Including mine.
And yeah, and counsel, if you can let me know, if there are any competency issues that arises so that we can make sure he gets where he needs to be.
Surely will, Your Honor.
All right, thank you. Anyone else ready?
I'm trying to get you ready, Judge.
All right, other than that, anyone else? Okay. Same thing. Okay, I'm going to depend on you all to teach me how to swim. Okay.
Being so kind. Then what happens? They know to the reps, they have all these questions, but they're all have on the on here. No other advice on for you.
Okay.
Because the state. You have to not only all of us. Anytime they don't speak on statements. So they're talking, they just said that. And then it's after work. So they said he was.
Can you do me a favor? Can I just put this on Cindy's desk? Thank you.
None of that. Was it a driver?
All right. Yaya, oh, sorry, Adriana. Oh, okay.
That's all shit. What part of she talks about oh, yeah.
Okay, do you speak Spanish? Trying to figure out what this medal says. I like the Fiesta medal. Okay.
Yeah.
I know some of it says no.
Okay, so. I left a cancel exposure. She's like, oh my God. Thank you. It's like,
Oh, okay. All right, I'm gonna tell them we need our medal.
that's.
Oh, I need another favor from you.
They never come. Oh, yeah. Yeah.
Oh, no, we're good. Thank you.
Quick question. It's gonna sound like a dumb question, but remember every part was a zero. So then on the GPS map, I wanted to approach with them without giving more time. Motions, I can actually suppose to block it over. Yes. Yes.
He was on jury yesterday, the first person was looking. So thank you. You also.
Okay. Okay. Choose 130. Back to 130. Put them home.
Man's left.
Thank you.
All right, I'm ready.
Adrian, is that for Theo? Can I blow that real quick so Bishop doesn't get mad at me? Yes, thank you.
Have an
Give me
update for the court.
2 minutes.
Yes,
May we announce on Mr. Stephen Limon?
yes.
Okay, so Bashan spoke with Ms. Damaron, very appreciative of that. She stated that they do have spots available. If the court were to send a referral, Ms. Abrams also had the great idea of cap evaluation. As probation does not have one on file for him.
Okay,
If the court saw suitable to order that, we would appreciate it, Judge.
all right. Bashan,
Yes, Judge.
when do you want this recalled for the, how long will it take for the tap evaluation? Okay,
Get it back sooner, I could let Norma know.
all right, so we'll recall it in 3 weeks and a referral to felony drug court.
And, okay, and I'll just do it under maybe probation.
Yeah, because that'll be easy. Norma? Oh, I'm sorry. I need a 3-week reset. It's on Stephen Lamone.
May we do May 5th, 3 weeks? That's the
Oh.
one my other case.
All right,
was.
Norma, can you put it for May 5th?
Awesome. Great,
Thank you.
appreciate that. Thank you.
Sure. And Bashan, you said we had new people here?
Yes, Judge, you have to. Officers.
Hi, where are the 2 new officers? They've chosen an occupation where people are overpaid.
You said overpaid or underpaid?
Overpaid, because
Overpaid.
if you put that in the universe, it will happen. You know, because I've tried hey, they need a raise, and that hasn't been working, so I'm trying to, they've been overpaid, so I'm putting it out in the universe that you guys get overpaid.
Thank you. Judge, this is Jordan and Josie.
Jordan, J&J.
Yes.
I can't switch you guys up now. So, what are you all gonna be doing? Probation officers or
Yes. Yes.
going out on field visits?
No, not on field visit unit. No, not just yet.
Well, welcome to the 187th, and you guys are welcome anytime. You have good people who are looking out for you. So you couldn't have chosen better people to bring you into the world of being a probation officer.
Yes, ma'am.
But it truly is a great profession, I think. And I always try to tell people, sometimes people overlook probation officers, but probation officers usually know more about what's going on with individuals than we do, because you all see them more often than we do. So you all are the backbone of the legal profession.
Thank you.
So, and y'all do need a raise, but Sean, they need a raise. All right, but if you guys need anything, just let me know, okay?
Okay,
Right,
thank
thank
you.
you.
Thank you, Jen.
All right, what page is this on?
Exactly right.
Oh, I see it. That's okay. I got it. Julian Teo.
We're present, Judge.
All right. All right, the court is calling 2025 CR 014516 State versus Julian Teo Jr. Can I have parties announced?
Brandon Prada for the state.
Good morning, Judge. Alfonso Cabañas for the defendant, Julian Teo Jr.
And are you Ms. Teo, Mr. Teo?
Yes, ma'am. Yes, Your Honor.
All right. Counsel, have you received all discovery that you reviewed with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Teo, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented
We are, Judge.
on both counts?
Oh, I'm sorry, Judge. We'll be waiving count one, we'll be waiving count one, proceeding on count two.
Any objection?
No objection, Your Honor.
And counsel, is this an application for deferred adjudication as well or no?
No, just regular probation.
All right. Mr. Teo, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
In count two, you're charged with possession of a controlled substance, penalty group 1B, 4 to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is.
Mr. Teo, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count two. They're asking that your punishment be assessed at 5 years in the prison. There's a $1,000 fine probated, and they're recommending community supervision. Did you understand that to be your plea?
Yes, Your Honor.
State defense, is that the plea?
It is, Judge.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be a TAP evaluation, 100 hours community service restitution, the DOEP course, and MRT. Did you understand those were recommendations from the state? And the court does not have to follow those recommendations.
Yes, Your Honor.
Then to count two, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
Judge will offer state exhibit number 1, including all attachments.
No objection to state one and attachments, Your Honor.
State, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consent stipulation of testimony and stipulations. Court will accept in the evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Just ask the court to follow the plea agreement with the state, Your Honor.
All right, are you employed?
I was recently hired, Your Honor.
All right, what do you do?
I'm a remote customer service representative.
All right, do you have any children?
No, I don't.
And if you're drug tested today, what are the results going to be?
Negative, Your Honor.
When's the last time you used?
Probably June, I want to say almost a year ago. I've been on probation from a different offense out of Denton County. So I've been doing drug tests for that probation.
And what are you on probation for in Denton County?
It was for possession of controlled substance, THC, a prescription that I had out of Oklahoma.
And are you still on probation out of Denton County?
Yes.
All right, how long are you on probation there?
Until June of next year.
All right, and what are your conditions there?
I'm sorry?
your conditions of probation there because, and the reason why I'm asking is because if you have certain conditions there, I don't want to double it up here if he's
No
already
problem.
doing it there.
So, I have 120 hours of community service that I'm working on. A TAP evaluation scheduled for June, and the DOEP, offender cart, the drug course that, I already completed last month.
Judge, and it's my understanding that even though it's in Denton County, he is reporting with the probation officer here in Bear.
Yes.
Okay. Do you have that cause number?
I do not, Judge.
Okay. Probation.
Yes, Judge.
Are you able to run concurrently whatever is happening with this case out of Denton County? The case is in Denton County, but I guess it's been transferred to Bear. Are you all able to see what his conditions are?
If it was transferred over, Judge, we could request a copy of the condition from this officer over there. I don't know that we would have it in our system now. You have the case number, Judge, I can look that up.
No, I don't have the case number, but his TAP evaluation is scheduled in Denton County, he says in June. So I wouldn't want us to do a second TAP if he's already scheduled for a TAP.
We can request, so it's judges instant, should send an SR to you. And then I could,
All right. So this is what the court is going to do. As previously stated, the court is finding the defendant guilty of count 2. There's to be regular reporting by Zoom or in person. Regular random UAs or the patch. $1,000 fine that will be probated. I'll notate that he has a probation case out of Denton County that's been transferred to Bear. He's informed me with the Denton County case, he's already, as a condition, he already has 120 hours of community service restitution. His TAP evaluation is scheduled for June 2026. He had the DOEP course that he completed last month. And the TAP evaluation, if he's transferred here, does the TAP evaluation take place here?
Yeah.
Oh,
yes, Judge, they would transfer it over.
okay,
Judge, if I may, I have the case number out of the 367th District Court in Denton.
okay.
That is F24-1761-462.
All right, probation, were you able to take that down?
Yes, sir.
All right, so if you can see what his conditions are and the conditions I'm going to give him now, if they're the same conditions that he has out of that case, just let him only do the conditions for that case. All right, so this is going to run concurrent with F24-1761-462 out of Denton County. And there's going to be field visits 1 time per month for 6 months. Proof of employment within 45 days. No employment as a home health care provider or with minors. No unsupervised contact with minors. And where you live, are there any children in the home?
No. Your Honor.
Okay. There is going to be 100 hours of community service restitution for every sober support meeting completed. An hour will be deducted from the community service restitution. And I'm going to sentence him to 5 years in the prison, suspended and probated for 4 years. Probation, is there anything else?
No, Your Honor.
Is there anything else you need from the court in order to be successful?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right. And do you have a current driver's license?
I do not, Your Honor. I just recently got a Texas state ID, but no
Okay.
driver's license.
All right, probation, I'm so sorry. One of the condition that needs to be added, there is to be no driving until you present a current driver's license and valid driver's license to probation. Do you understand?
Yes, ma'am.
All
Yes, Your
right,
Honor.
thank you.
Thank you,
Thank
Judge.
you.
Thank you.
So what's the? Yay. Okay, all right, awesome. Yay. Oh, it is. It is beautiful. I think it's gorgeous. It just makes you happy, right?
I told it was perfectly silly.
Yes, I love it. All right, who's next?
I have a Jeffrey. All in online. Wait, what is it now? All right, I'm.
Jesus.
I'm sorry, I can't read your handwriting.
That's okay. Jesus Alamon. All right, where are we on discovery?
Judge, they have sent to discovery.
All right, state, were you able to tender an offer?
An offer was made, Judge.
How old are you?
19,
I'm sorry, how old?
19.
19.
Yes, ma'am.
Norma, set this for 30 days for plea deadline date.
Yes.
Thank you, Judge.
All right, you need to make sure you're on time for court. I understand that you're young, but court is at 9. Are you in school? What are you doing?
He's working, Judge.
All right, so you need to make sure you're on time. You understand?
Yes, ma'am.
All right, once you sign the reset form, you excuse.
Thank you, Judge.
Thank you.
You're welcome. Who's next?
I'm sorry, Judge, I'm getting.
All right. Anyone else ready? Who's your client?
Kilpatrick. Just, it's a reset, Judge.
Kilpatrick? Have you conferred with the state?
I have, Judge. We have received an offer. I believe I've received all the discovery. I'm gonna review with my client.
All right, court starts at 9. You now know where it is, okay?
And what else?
All right. All right, Ms. Ferguson, I need a 3-week reset for plea deadline date. All right, once you sign the reset form, you'll be excused. We'll be back on the 5th. At that time, you need to let me know whether or not you reached an agreement.
Appreciate that, Your Honor.
Thank you. All right, anyone else ready? Okay. Michael Betts. Oh, let me see. I'm just recalling the name that they've given me. What page is he on?
Page 5. And he's going down.
Justin Bettis, please. Court is calling 2026 CR 003-180 State versus Justin Bettis. Can I have parties announced?
Lauren Espinoza for the state.
And Valerie Headland for Justin Bettis.
Are you Mr. Bettis?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I have, and I did.
Court will find that the state is in compliance with discovery. Mr. Bettis, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am, I did.
And to review the true bill of indictment with your attorney?
Yes.
Did you understand it?
Yes.
Counsel, do you waive the reading?
Yes.
State, are you proceeding as presented?
No, Your Honor, state moves to proceed on the lesser included of attempted assault of a hospital pursuit.
And no objection.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right, the state is proceeding on the lesser included offense of attempted assault on a hospital personnel. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Bettis, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
I am.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did.
According to the plea, the state is proceeding on the lesser included offense. They're asking that your punishment be assessed at 2 years in the state jail facility. They're recommending community supervision. Did you understand that to be your plea?
Yes, ma'am.
State defense is at the plea?
Yes, Judge.
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both
I
places?
did.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation, 100 hours of community service restitution, no contact with Judith Ramirez, the APSE course, MRT, regular random UAs, and the mental health evaluation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense, how do you plead?
No.
Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor, state offer states exhibit 1 and all attachments.
No objection.
All right, state, you may be excused.
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after viewing states exhibits 1 and attachments, court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, please.
Anything you wish to say on behalf of your client?
Judge, Mr. Bettis has been homeless for probably
5 years.
5 years. And he does have a case manager with Haven for Hope that I wanted to verify, but I won't be able to, but I'm sure probation will. We've filled out all the information for her. So I'm hoping he can be released directly back to Haven for Hope. Other than a 2019 case out of Hayes for a misdemeanor ABI family, he doesn't have any other Texas criminal history. He has various drugs, alcohol related from Florida, from up until about 2005. But he really doesn't have an extensive history and not extensive violent history by any means. He does admit an alcohol suffering from alcoholism. So I'm hoping that the TAP eval will identify and help him with that, which is part of the reason why I think probation is good for Mr. Bettis so that he can have services. He also needs some assistance with like an identification. He does take medications. He has disability that he hasn't been deemed disabled to receive benefits, but he's been working on that prior to his arrest. He has osteonecrosis, which is a debilitating arthritis, I think, because of his homeless situation and just overall health and probably alcoholism related, and various other things. But I would love to see Mr. Bettis get on his feet and have the support. And I think being under the jurisdiction of probation and the support that I think he could get some much needed help and assistance and get his life on track.
All right.
And just to explain the night of the event without giving excuses, it was 24 degrees that night. And so he had gone to Baptist to kind of submit himself for intoxication detox. And then upon waking, were going to ask him to leave the hospital. So he took all the trazodone and hydroxyzine that he had in his pocket. And so he was pretty well out of it, which I explained to him that intoxication is not a defense to what he did.
So where is your family?
My father's currently at Haven. He has 0 record. He's trying to get housing.
No, I mean, do you have any other family? Do you have children?
No,
All right, so,
His mom passed in 2021.
my sister lives in Florida.
okay. All right, this is what I'm going to do. I'm going to find you guilty, sentence you to 2 years in the state jail facility, suspended and probated for 2 years. Regular reporting by Zoom or in person, regular random UAs, no contact with Judith Ramirez, 100 hours of community service restitution. For every sober support meeting that is completed, 1 hour will be deducted. TAP evaluation and referral to felony drug court in custody. Felony drug court will be able to help you obtain your ID, give you the proper resources you need. They'll also be able to help you with housing and help you with any substance abuse issues you may have. Because it's Tuesday, felony drug court will get the referral to them today. They'll probably be able to see you before the week is out, but at the earliest, maybe Monday. And you need to be honest with them, right? There is to be proof of employment or SSI within 45 days of release. There's to be no employment as a home health care provider or with minors. MIC evaluation out of custody. No residing in households with minors. Probation, is there anything else that's required? Thank you. Field visits 1 time per month until further notice.
And I apologize, did you say 100 or 200 community service hours?
100.
Thank you. Nothing else.
Is there anything else you need from the court to be successful?
No, what I was going through at Haven for Hope about my ideas for my birth certificate, my social security card are opposing names.
All right, no. So what you do is hopefully you will be admitted to felony drug court. And you let them know what your issues are. It's really a wraparound service at felony drug court, okay?
Okay, thank you.
And Judge, just so that he understands, you said the evaluation for TAP and felony drug court will be in custody.
In custody.
Okay, so Monday. maybe.
All right, and the felony drug court evaluation will probably occur before the TAP.
Okay,
And if he is admitted to felony drug court, then felony drug court will be responsible for any other conditions. I won't set the conditions. Some of the conditions I have set, they may say they don't think it's appropriate and do something else. Okay.
and Judge, just, I'd like for you to advise him that, regardless of his housing situation, that it's important that if he finds himself where he can't report or is struggling with probation, to come back to this court, to
He needs to.
make sure that
You have
he-
till December to come back and see me.
Oh, just show up?
well, if you struggle, you can contact me or come back to the court.
Yes.
Just don't hit the street and don't come back, okay?
All right, thank you.
Thank you, Judge.
All right, Roger, you need to speak to the caseworker for your client.
Great, and the caseworker is.
Just 1 second. So on your case, it's also been reset for July 26th. The caseworker for Mr. Perez, this is the defense attorney.
And then could I just approach you briefly on another, Mr. Suarez? We wanted to just bump it. We think we're gonna get a resolution in a lower court, maybe resolve it here also. This is on Suarez. Could you repeat that date you mentioned? You just told me.
It's July 26th. Oh, you may want to go talk to her because she's been.
No, I will.
All right.
So on Mr. Suarez, is that?
Oh, no, you should talk to her first. Thank you.
Yeah.
Oh, yes, July 26th, sorry. Yeah. Could you let him know? Oh, yeah, no, it's the 26th. You're correct. Well, that's the date y'all gave me. Well, what date do you want it? All right, July 7th then. All right, thank you. Okay, I have it in the system for July 7th.
Yes.
I'm being gaslit. Okay, thank you. I have it the 7th in the system. Thank you, Paris. All right, someone here has the interpreter. Who is that for?
That's for Adan Silva.
Can I have a motion to that?
All right, have you conferred with the state?
Yes, Judge.
He's on page 7, Judge, it's fine.
Okay. All right, I need his probation file. The Don. Yes. Oh, no problem. Oh, yeah, you can just give me the whole file. Thank you. All right, court is calling. 2021 CR 9571. Who's here on Aiden Silva? And who is the prosecutor? Okay. All right, good morning. All right, the court is calling 2021 CR 9571 State versus Aiden Silva. Can I have the parties announced for the record?
Megan Galloway for the state.
John Winter for the defendant.
All right, we have an interpreter. If you could raise your right hand. Do you solemnly swear and affirm you will translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Cesar Chavez, license number 2203.
All right, and are you Aiden Silva?
Yes.
All right, defense has filed a motion for early termination of deferred adjudication. State, are you opposed?
Judge, not exactly. We would just request that you wait to grant the motion until May 1st, 2026.
All right, and is there a reason for the request for May 1st?
Just due to upcoming festivities in the city and prior alleged alcohol use.
All right.
Well, Judge, he's done very well on probation. And the probation office has no objection to him being early terminated as we stand here today. He's managed to go through prior fiesta events with no issues at all. In fact, he tells me he doesn't drink. I don't know if you want to put him on the record as far as that goes. But he's entitled to it. We just ask that it be granted today.
I mean, is he really entitled to it? Because he's supposed to be on probation for 5 years. I mean, he can request it.
Agreed.
Okay.
Yes.
All right. Probation?
Judge, I just want to point out, he has completed everything that has been asked of him. He did complete the 6 months of the UA IVR hotline without any issues. His previous UAs that were for alcohol were found to be medically related.
Okay.
At this time, the probation department has no issues with Mr. Silva being discharged early.
All right.
Just
So
really quick, Judge, the alcohol use that I was referring to is not what is medically related. It's the facts and circumstances that led him to the assault an elderly person. And so that's my concern with the upcoming festivities. I just want to make that clear.
And so when is his next report date with probation?
Judge, let me double check and see if that is.
I believe he told me he has to report next week.
Oh, is your report next week?
Sábado. This Saturday.
So he's under the late, at this point, Judge, because he has finished everything. So one of the perks of being on this maintenance caseload is that they do a quick check-in on Saturday.
All right. The court will grant early termination to take effect on May 6th. The court's granting of early termination will take place or be in effect beginning May 6th.
Yes, Judge. Here's the paperwork from probation.
All right, thank you. Is there anything else?
No, you're,
All right, thank you.
thank you.
You're welcome.
May I approach?
Yes.
Haven't agreed if bond sitting on an MTR.
Just give me a moment.
Bye-bye, Judge. Continue.
Thank you. Have a good one.
Oh, yeah. Michael Hernandez.
All right, is John Young needs to be placed on for this.
Yeah, yeah, yeah.
Okay. All right, can you send me that to probation? Is he appointed on that?
No, I'm hired.
No, he's just, yes, just put him down to be heard. Is his client here?
She is not, Your Honor. She's in jail.
Oh, I require that they be present. I mean, if you want to take it to,
Navarino?
magistrate court, yeah, you can take it there.
I will do that then.
Okay.
Thank you. Then I will
Alex?
do that. Thank you.
Okay, thank you. Alex Miosek,
Yes. Well.
are y'all ready to proceed on the MTR?
No.
Norma, I need a contested hearing date, 14 days. All right, April 28th, contested hearing. All right, thank you. Once you sign the reset form, you're excused.
Yes, sure.
What day is it?
April 28th.
Okay, thank you.
And to both parties, today was supposed to be your contested day. There will be no further resets for contested hearings.
Yes, Your Honor.
Thank you.
Real quick, Judge, if we needed to make it sooner, would that be okay?
It's going to be on the 28th. All right, who's next? Michael Hernandez.
Judge, on that one, I just wanted to approach Judge. The state didn't have the files.
Oh, where's your client?
He's here, Judge.
He needs to come forward.
Reports this stuff. Mr. Hernandez, please go up.
Hello.
Hi.
All right, court starts at 9 a.m.
Yes,
You
ma'am.
now know where court is. Do not be late again, okay?
Remember.
Norma, I need a recall date, 30 days for discovery. All right, once you sign the reset form, you're excused.
Yes, ma'am.
Thank you.
Thank you, Judge. May I be
Welcome.
excused?
Yes.
Thank you, Judge.
Who's next?
Yes, ma'am.
Adam Vasquez. All right, where are we on discovery?
Your Honor, I believe that we probably have everything that we need, and we got it offered today.
How old are you?
32. I'm sorry. I was the same thing.
Okay, Norm, I need a plea deadline date in 3 weeks. All right, once you sign the reset form, you will be excused. I'll see you back on May 5th.
Yes, ma'am.
Thank you.
Have a great one.
You too. All right, who else?
Yes, I'm preparing the docket. I'm preparing a plea for you, sir.
All right, anyone else ready?
No, nobody else has signed.
Okay. Oh, he has to sign them in. Yeah.
Right, I've got 15 on my.
Okay. Manuel Alfaro. Miguel Dominguez. Are you here?
Yes.
You need to be sitting on the second row. Victor Della Vega.
Councilman's present, Your Honor, he's outside of the benches. I am conferring and will be ready in about 5 minutes tops.
Okay. Jose Alfredo Perez. All right, thank you. Yeah, I will.
Mr. Ortiz? Oh, here, okay, thank you. I'll bring it right back.
Jose Torres. Come forward. When are you gonna have it? Hi, when are you having an attorney?
I'm just in a couple of weeks just to settle with them.
All right. This is coming back on May 14th. At that time, you need to have an attorney.
Sure.
All right,
problem.
Ms. Ferguson, reset it for May 14th.
I just didn't even know I had court today.
Mhm.
So I called him about it. He goes, but I can't go. So
All right, see you on May 14th.
Thank you, ma'am.
Your attorney needs to be here.
yes, ma'am. They're great.
Yes. I'll take care of that in a moment. And Deputy Mahia, when you have a chance, could you bring out Eugene Brown?
Yes, ma'am.
Thank you.
You trust the people remember exactly what I said. Okay. No, she's gonna send these.
That was.
Oh. I'm ready.
And she's on. Well.
Kendall Ortiz. Is there an application for deferred?
There is, Judge.
All right, the court is calling 2025 CR 0111383 State versus Kendall Ortiz. Can I have parties announced?
Courtney Allensworth and Ashley Jones for the state.
Don Flannery for Miss Ortiz.
Are you Miss Ortiz? Counsel, you received all discovery. Did you review it with your client?
I have and I did.
Court will find that the state is in compliance with discovery. Ms. Ortiz, did you review the application for community supervision and deferred adjudication with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Proceeding on count one and waiving count two.
Any objection?
No objection.
All right, did you review the court admonishments with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in all the appropriate places?
Yes.
All right, in count one, you're charged with abandoning and endangering a child, and placing the child in imminent danger of bodily injury as a second-degree felony. Range punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Ortiz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 4 years in the prison. There's a $1,500 fine. State is silent on your application. They're asking for an affirmative finding of family violence.
That's correct.
That is correct, Your Honor. I believe the court will see from the facts.
All right, thank you.
Thank you, Judge.
Affirmative finding of family violence, you're not allowed to be designated a primary custodial parent, and you're not allowed to own or possess any weapons or ammunition. Did you understand that to be the entirety of your plea?
Yes.
Defense?
Yes.
State?
Yes.
That's the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Any such motions?
No, Your Honor.
Then to the offense in count one, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence
State's Exhibit 1
No objections.
and attachment?
and attachments.
All right. Any objections?
No objections.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Is there any other criminal history with your client?
No, Your Honor.
All right, do you want to proceed with sentencing?
No, Your Honor, would like to be
Do
assigned.
you want to proceed with sentencing?
Today?
Yes.
we would like to do a PSI so that we can. let the
Do
court-
you want to proceed with sentencing today?
Your Honor, can we confer for just one moment?
Sure.
Thank you, Judge.
Your Honor, we're of the opinion that if we prepare a sentencing memorandum and we prepare for sentencing, the court will be most inclined.
Do you want to proceed with sentencing today?
No, Your Honor.
All right.
Yes, Your Honor.
Yes, to.
Proceeding the sentencing.
All right. Anything you wish to say on behalf of your client?
Yes, Your Honor. Miss Ortiz is a mother of four children. When this occurred, she was pregnant, many, many months pregnant. She had 3 children in her car that she was taking to school. She's not a single mother, but she's a stay-at-home mom, obviously. When she went to the school, it wasn't the summertime, it wasn't hot outside. It wasn't the wintertime, it wasn't cold. It was probably 70 degrees. At the elementary school that her young child goes to, she has to run him in. She's got 2 youngsters sitting in the back seat.
But here's the thing, and I understand where you're going with your explanation, but there is no explanation for this. One, I think everyone knows you don't leave children in vehicles, no matter if you think you're going to be going in for 2 seconds or a minute. Number 2, everyone knows, and I don't know what it is about Texas and other people loving their guns. You know, let me go to sleep with my gun. Fine. I'm fine with people owning guns, but if you're going to own weapons, you need to be responsible.
Judge, it's not her gun.
No, but here's the thing. Children are alone in a vehicle. There's a gun. Do you know there was just a news article where some toddler shot their brother in the head with a gun? That child is dead. And guess what? That toddler is never going to get over the fact that they killed their brother, whether or not it's their fault or not their fault. And it's really not their fault because there is a reason. What did they tell us in law school? The reason why you had, what is the term they use? The reason you had to have fencing around your pool. What kind of danger is that?
That you invite it. Yeah.
No, it's
It's a
something.
nuisance.
Oh my God. No.
Fighting the nuisance.
Defense attorneys. Thank you. It's an attractive nuisance. That's why you have to put a fence around it. And with regards to guns, what I've discovered in my time on this planet, no matter how often you tell children, this is not a toy, this is dangerous, they want to pick it up. I remember watching, what was her name? Kamora Lee Simmons. There was a clip, she was shopping for a home, right? And so she tells the realtor, I have little children and you're taking me out to a pool and there's an open fire, right? And she said, I know it's a fire, it's hot, but I want to put my hand in it because this just seems like there's water running over the fire. Let me touch it. So your child could have been killed, or either they could have ended up killing someone else. And if they would have killed someone else, you would have been charged with that. If they would have killed their sibling who was in the car, you would have been charged with that. And guess what? That toddler would never have been able to get over that. Even if they were able to black it out and their psyche is protecting them, at some point it would come up at some reunion or something that at one point they had a sibling. Do you understand?
Yes.
Judge, there's something that the court needs to be aware of.
Yes.
So she didn't know the gun was in there. Her husband left the gun in there, unbeknownst to her. Now, obviously, she shouldn't be leaving the kids alone because these are the sorts of things that can happen. When she found out, she was mortified. She immediately, she almost went into labor, had to go to the hospital for several days. She had no knowledge that the gun was in
Where are
there.
the children?
What?
Where are the children?
Where are they now?
Yeah.
They're with their babysitters right now.
Okay. And was Child Protective Services called? 'Cause
Absolutely.
usually they are.
Absolutely.
So
They
what
would-
is the result of Protective Services?
They told me it was an isolated incident and they're safe
Had
at home.
children
I-
returned.
I com-
So they fully investigated all of this. They, and we-
All right, so this is what I want you to understand. And I hear your attorney's argument and I appreciate his arguments because he has to represent you, but I'm trying to instill in you that at any second from something we did or didn't do, children can be taken away by CPS or because there's some danger. And based upon what I read, if you would have ran into a grocery store, right? And nobody, you were not parked in line and no other parents came, because the only reason why your child dropped that weapon and hopped over in the back seat is because another parent came to see what was going on. And then game over. And then you would have been devastated. Your child would have been devastated and you would have lost the child. You can't be doing that. And I can tell you right now, I'm going to order that you have no weapons in your home.
Absolutely. Well, and that's why that's why we insisted to have the affirmative finding of family violence, so that for the rest of her life, she can't have a firearm. Even if you give her deferred and she's not a felon, she can never own a firearm, because we don't want the husband to think, well, I can have a firearm, because none in the home. So that was a big sticking point on our point, because we wanted to make sure, because ultimately this is her husband's fault. Now, he wasn't charged, he's not culpable. They've dealt with that and they've dealt with him. He's obviously very upset about this, but I'm mad because it's his fault that she's in this position. But then again, she should never have left the kids in the parking lot.
Yeah.
And that's why we're here. But I think with the affirmative finding that we came up with, it's a way that you can ensure she can never have a gun, and more importantly, that husband can never have a gun in that home. Because that's the most important thing.
And the other issue, when you leave children alone unattended, a stranger can come up and take your children.
Anything
I don't
can
know why in San Antonio, people think that, oh, I'm just going to let my child run around. That is why I really don't go to the mall. You know why? Because I end up having to watch other people's children because they're letting them walk behind them. And then it's like I'm a stalker trying to make sure this child is not lost. All right. Probation, are you ready?
I'm ready, Judge.
This is what the court is going to do. Count one, the court is going to sentence you to 4 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs or the patch. Are you employed or stay at home?
I stay at home, but I am a part of the San Antonio Ready to Work program.
All right, proof of employment within 45 days, no employment as a home health care provider or with minors. There's a $1,500 fine, time and money to run concurrently. All right, with regards to this affirmative finding of family violence, how are you all saying that this is an affirmative finding of family violence?
Your Honor, was trying to look it up, but the internet is down. I was trying to get the exact wording for you.
Because I'm trying to see the connection. Because I mean, either way, I'm
Well-
going to order that she not have any weapons.
Right. Well,
I mean, that would
the
be
reason would
sufficient,
be
Your Honor.
logically is that, and I'm not usually the one to argue in this position, but I do believe that it's helpful, is that the child is named as a victim in the indictment. Now statutorily, if that doesn't do it and the
So-
court isn't inclined, I understand that as well.
Just from my memory of the statute, and I am trying to find it in the book here, it placed the child in a risk for bodily injury, which by statute, I believe, is sufficient. If you'll just give me one moment to find that, Judge.
Okay, so let me see.
130. Is it 71?
It's 42.013.
Yes, but you have to look at 7101. I'm sorry, 71004 of the family code, Your Honor, which I
Yes.
don't have access to at the moment in this book.
Well, let me see if it's in there.
Okay. It should be looking now if there's.
Well, their thing of family violence and what it means. They say family violence means an act by a member of a family or household against another member of the family or household that is intended to result in physical harm, bodily injury, assault, or sexual assault, or that is a threat that
And
reasonably places the member in fear of imminent physical harm, bodily injury, assault, or sexual assault.
so that's kind of where we were going with it, Your Honor, but if the court doesn't agree, I mean, it's the court's finding.
I mean, if
so-
y'all want to
Well,
file a motion and say that I'm incorrect, I will of course review it, but based upon my reading of the code, this is not an affirmative finding of family violence. So this is what I'm gonna do. 4 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs or the patch, proof of employment within 45 days, no employment as a home health care provider or minors, $1,500 fine, time and money to run concurrent. You all agreed on a affirmative finding of family violence, but my reading of the law and my reading of the fact pattern, the facts that y'all have, it's not an affirmative finding of family violence. So if that is what you all consider to be not following your plea bargain agreement, now's the time to let the court know.
No, Your Honor.
no, Your Honor.
All right. There's to be no possession of firearms or ammunition. There's to be no firearms or ammunition in the household. There is to be 200 hours of community service restitution. 100 hours will be deducted. I'm going to require parenting classes. The other 100 hours will be deducted upon completion of a gun safety course. There is to be field visits 1 time per month for 8 months. Compliance with CPS if applicable. Probation, anything else? Anything else you need from the court in order to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. I cannot stress enough to you what could have ended up happening. And it wouldn't have been good for you or anyone else. It wouldn't have been good for the people who would have had to come on the scene to address that. People who have weapons need to fully secure those weapons. And anything that you have around your household that is attractive nuisance needs to be secured.
Yes, ma'am.
That is another reason why when you have cleaning supplies, people say lock those from toddlers. When they start crawling, they get into everything. They put everything in their mouths. Okay?
Yes, ma'am.
All right, once you speak with probation, get your conditions, make sure you stay in contact with them.
Okay.
Oh, just 1 second. Yeah, I did do 4 years deferred. All right, good luck to you.
Thank you.
Thank you.
Judge.
Thank you.
Who's next? 1 Suarez.
We're present, Mr. Suarez is present also. He doesn't have the right attire, but he has a matter pending in the,
Oh, where is he?
he's
Tell him
he's
to come.
got shorts on.
Tell him to come up.
Suarez.
Yeah.
So he has a
Oh,
Good morning. I just wanted to let you know beforehand, I apologize for my.
all right, but here's the thing. I always tell people, when we know better, we do better.
Yes, ma'am.
So now you know, one, court is at 9 a.m. You know where this court is located.
I was swear.
Okay, no problem. And you know what attire should be, right? And I would always tell my clients, nobody's asking anybody to show up in a three-piece suit. I always tell them, if you have jeans, not the fashionable ripped jeans. I said a jean and a shirt, you're good to go, okay?
Yes, ma'am.
All right, so counsel, what do you say is happening with a misdemeanor case or something?
Yes, there's a pending misdemeanor case. Upon resolution of that, I think we're going to be able to resolve this matter promptly.
All right, and when is that set?
The matter hasn't been resolved in County Court 12, so we're going to,
No, I mean, when is it set in County Court 12?
today. So we're going to go back down there, but the BAC, one piece of evidence hasn't come in. So we're going to ask for about another 40 days or.
What? No, I'm gonna recall this in 3 weeks. Tell them they need to have it in 3 weeks.
Right. Very good.
All right, we'll be back on May 5th, okay?
Yes, ma'am.
All right, thank
Have
you.
a nice day.
Yeah, you too. All right, who's next? De La Vega? Victor De La Vega? Hello.
Good morning, ma'am.
Good morning. All right. First things first, you were late. Court is at 9 a.m. Now you know where the courtroom is, so there is no excuse for you to be late next time. You understand? All right, counsel, where are we on discovery?
Guys, we're okay with discovery. We've actually have an agreement to submit a pre-trial diversion application.
All right. Norm, I need a PTD date. All right, let me give you a PTD date. Just a second. Let me see, it's April 14th. We'll put you on May 19th. May 19th. Norma, on this case, recall it for May 19th. And it's PTD. All right, is Mr. Eugene Brown out here? All right, Mr. Brown? Hi. Okay, Mr. Brown, your attorney is out ill. So your case is gonna have to be reset. So I can reset this. It'll probably be reset for 30 days because he's out ill. Or I can have another attorney appointed to represent you. It's completely up to you.
Today? You get one today? Yeah.
You want another attorney?
Yeah, you get one today.
All right, just have a seat and we'll get you an attorney.
Yes.
All right, and who's next?
Mr. Freeman.
All right. Mr. Freeman, if you come down, please.
The next contestants.
Yeah, I never thought I would, there are certain things from law school that you never think you're gonna use. I remember one time I had to use curtilage and I was like, yes. And then this time I was like, what is it called? Oh, yeah. I was glad you guys remember. Attractive nuisance.
I've had a few of those at my house. I've had a
And people don't realize. And I remember with my nieces and nephews, it's like we got down on the ground to let's see what they see so we can make sure we have everything secured. When they start walking, it's a great thing, but
yeah.
they get into everything and everything. They want to put everything in their mouth.
Got to cover up our outlets over Easter holiday because our little nephews were crawling around.
Yes.
We haven't had toddlers in a long time.
All right, court is going to call 2025 CR 006852 State versus Marcus Anthony Freeman. Can I have parties announced for the record?
Orlando Castañon for defense.
And are you Mr. Freeman?
Yes, ma'am.
All right, you entered a plea of guilty on March 10th. According to your plea bargain agreement, punishment is to be assessed at a cap of 8 years in the prison. There's a $1,200 fine. State is opposed to your application. They're taking in consideration 2025 CC 14050 and 2025 CC 005777. There's to be restitution of $719.74 to First Class Motors under 2025 CC 014050. Could I have parties announced?
Lauren Espinoza for the state.
Oh, I'm sorry, you already did announce. I'm so sorry. All right, have both parties had a chance to review the PSI and TAP evaluation?
Yes, Judge.
Yes, Judge.
Any objections from either party?
I have no objection, just
The state, Your Honor.
modification and some language.
Yes, with your modification.
Well, so it said that I think his motivation was moderate. I believe he's highly motivated for treatment. I can't recall where I saw that, but it seemed to make his motivation appear to be lesser than I think it is.
Okay. Any witnesses from either side?
No, Judge.
None from the state, Your Honor.
All right. So this, I will hear argument for both parties. Of course, I'm going to keep an open mind. But in reviewing the TAP evaluation and from seeing Mr. Freeman before me, they are requesting dual diagnosis. There appears to be some mental health issues and maybe some capacity issues. Am I correct?
Yes, Judge, and that was one of the things I wanted to ask the court because on the PSI, it does list the prosecutor as Bianca Herrera, and I know she is associated with mental health court, so I wasn't sure if
We
she
did
was
at one point have a
approved or-
competency evaluation done. He was found to be competent. And so, when I had requested that, it was sometime, I believe, around November or so. I believe there had been possibly some issues. I know there had been some, I think, previous findings possibly of
They just diagnosed me with high blood pressure and they gave me more of my mental health needs.
so he's been on I think, had some mental health issues before. He may have had a competency evaluation previously. He had stated that he believed that to be the case.
All right,
some years
so this is what I'm going to give you all choices and you can sit back and discuss it with your client. The first choice is I will deny the motion, sentence him to 3 years in the prison, or I will grant his application for community supervision. I'm not going to grant an application for deferred adjudication because of his history. I would find him guilty, sentence him to 6 years, suspended and probated for 6 years. do a referral to felony drug court, because felony drug court will be able to address mental health issues. They will be able to address any type of drug issues. Those are the choices.
Okay, let me take a moment to speak with them.
Sure. As you can see, in this case, there are major mental health issues, and then you have this. It's a lot going on. But whenever you review these, pay attention to,
Yes, okay, Judge.
yes,
So my client, after discussing with, and we discussed earlier that he was not opposed to even waiting for a bed for DDRF if that was the case, but he is wanting to be granted community supervision. He said he's 48 years old and he is done with, and he said he wants help and treatment. So I believe that's what he would like to do. So if the court so chooses to put him in drug court, then I believe, and I explained to him that, the underlying sentence would be 6 years. So if he violated the terms, that he would then be sentenced.
all right, the court will sentence you to 6 years in the prison, suspended and probated for 6 years. There's to be regular reporting by Zoom or in person. There's to be a referral. Okay, this probation, this is take place in custody. There's to be a referral to felony drug court. If not accepted, then he's to remain in custody for evaluation for DDRF. And if not accepted there, then it's going to be safety. Take in consideration 2025 CC 14050 and 2025 CC 005777. There's to be restitution of $719. I'm sorry, just one moment. All right, we are back on the record. So there's to be restitution of $719.74 to First Class Motors and 2025 CC 014050. Field visits one time per month until further notice. There's a $1,200 fine that will be probated. Probation for this one, I'm not gonna order the community service hours because there's not gonna be a place for him to complete that. But I will do a proof of employment or SSI within 60 days of release. No employment as a home healthcare provider or with minors. No residing in households with minors. And no unsupervised contact with minors. Probation, is there anything else?
You did a regular UA, right?
No, regular random UAs.
Okay, good. There's nothing else.
And state, is there anything you would request as conditions?
No, Judge, I think that's fine. I don't anticipate any contact with the TIC case complainant. I think that's sufficient.
All right, is there anything else you need?
No.
Defense, is there anything else you think your client would need to be successful?
I don't believe so, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, you review this and sign it.
Well, son, yeah.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, good luck to you, okay?
Thank you, Judge.
Thank you.
And briefly, if I could, on the appointment.
Yes.
I've spoken with the state, I conferred with my client,
Mhm.
discussed that I do need to review his discovery. And I'd be asking for a new portrait on that.
Okay. Mr. Eugene, if you come forward, please. All right. We're just gonna go on the record briefly.
Understood.
The court is calling 2026 CR 003034 and 2026 PF 10707 State versus Eugene Brown. Are you Eugene Brown? Yes. Can you raise your hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Eugene Brown.
All right, Mr. Brown, you were given a court-appointed attorney, Mr. Garcia. Mr. Garcia is going to be out for a while due to medical. It was the court's understanding that you were requesting that the court appoint another attorney for you. Is that correct?
Yes.
All right, and that attorney is Mr. Castagnon. Do you have any objections to his appointment?
No.
All right, thank you. We can go off the record. How much time are you asking for, counsel?
30 days, Judge.
All right, Ms. Ferguson, if you can recall this in 30 days for discovery. All right, so we're going to be back on May 14th, and this will be your attorney, okay? All right, thank you.
Thank you, Judge.
You're welcome. Yes.
Page 3, 2, yes.
Isidro Sanchez.
Good morning, President.
Wait a minute, what page did you say?
Hold on a second. We might have gotten here. Page 6, one down.
Yeah.
Okay, ma'am, page 6, one down. Sorry.
One minute. All right, where are we on discovery?
Judge, we're not complete on it. I also pointed out
What's missing?
the interview of one of the material witnesses.
Anything else other than that?
Not that I know of, Judge.
All right, Ms. Ferguson, I need a reset date for 30 days and state you'll need to be prepared to tender an offer.
Of course, Judge.
All right, May 14th. Sir, do you have any questions?
No, Your Honor.
All right, we'll see you back on May 14th.
Thank you.
Thank you, Judge.
Thank you. And then your other client, Mr. Wolf?
Yes, Judge. Oh, May 14th,
Yes.
I have a doctor's appointment that day.
All right, Norma, he has a doctor's appointment
Day
that day.
before, day after, any other day that week.
Okay,
12 works.
all right.
Thank you. Doctors are like that. 6 weeks out, 2 months out.
Oh, no, I hear you. Just 1 second. All right, and then your client, Manuel Alfaro?
Manuel Faro, I believe, is not present.
All right, Deputy, could you make an announcement for Emmanuel? Oh, sure.
And I've got one other judge, and that's Derek Herney.
All right.
Page 5, 4 down, Judge.
Derek Kearney.
And judge meet a plea deadline.
All right. Norma, set this for a plea deadline date then on May 12th. All right. We will see you back on May 12th.
And then the other thing, other than that, is Judge Alfaro,
Yes.
my understanding is that
Oh, well, we will see.
when they find him.
All right, could I have the court is calling 2026 CR 0022522 State versus Manuel Alfaro. Can I have parties announced?
That way for state.
Warren Wolf, Mr. Alfaro.
All right, this hearing was scheduled at 9 a.m. It is now 11:46 a.m. Defense, your client did not answer docket. Where is your client?
I haven't had any contact with him today.
All right, state.
Requesting a bond for sir.
All right, the court will issue a judge's warrant, remand your client without bond. All right, who else is ready? The court is recessing at noon. Right? Equivalent, right? If you'll come down. All right, where are we on discovery?
I need to download it, Judge.
State, were you able to tender an offer?
We were, Judge.
Yes.
All right, Norma, set this in 30 days for a plea deadline date. All right, we'll see you back on May 14th.
Thank you.
Who else is ready?
Drummond.
What page, Norma?
Is that page 4?
Miguel Dominguez.
Yeah, I know. I'll work on the paperwork.
Good morning.
We're just requesting additional time at the first setting. We'd like to review discovery.
All right, where are we on discovery? Is this a blood draw? What is this?
It's a blood test.
All right, have you filed for blood discovery?
I have not, Your Honor.
All right, Norma, I need a discovery reset for 45 days. You all need, if there's a blood test, a breath test, you
Well,
all need to follow.
We have the results, Your Honor, but.
Oh, okay.
Yeah, so I just need some additional time to review the videos with him and do that, so.
Defense, I'm sorry, state, have you tendered an offer?
Yeah.
I've been defense for a while, but yes, yes, Judge, an offer has been tendered.
All right, Norma, set this for a plea deadline date in 45 days. All right, May 28th. Once you sign the reset form, you excuse.
Thank you.
Make sure you're on time.
Yes.
All right.
On this side with the red hair? No, Ashley Jones.
You on page 2 at the bottom?
All right. Adames.
Yes.
All right. Morning. All right, so where are we on discovery?
There were two issues, Judge. The first is regarding the case before you today. We are missing a body cam video from one of the arresting officers.
Okay,
We have let the state know that, and they said they would get it to us.
okay.
Also, my client recently got arrested for 5 new felony cases, 2 of which were sealed, 3 of which just happened on the end of last month. I was just appointed on those maybe 10 days ago, and we haven't received discovery on any of those cases yet. And the state said they would get us that discovery.
All right, Norma, recall this in 60 days for discovery and state at that time you'll need to be prepared to tender an offer.
Of course, Judge.
Thank you, Judge.
All right, we'll see you back on June 15th.
Thank you, Judge. May I be excused?
Yes.
Thank you.
Okay,
You on page 4.
how much Jason Wolf have? He's been here all day.
They just turned in. Let's do back to this.
Okay. All right, Juan Reyes. What page is Juan Reyes on?
Page 4, 5 down.
Court is calling 2026 CR 003093 State versus Juan Reyes. Can I have parties announced?
Lauren Espinoza for the state.
Roberto Vargas for the defendant, ready to proceed, Your Honor.
All right, and are you Mr. Reyes?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Reyes, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeding on the lesser included offense of possession of a controlled substance, PG1, less than 1 gram.
Any objection?
No objection, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you enter a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Reyes, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed under possession of a controlled substance penalty group 1, less than 1 gram, of 180 days in the Bear County Jail under 1244 and an $800 fine. Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Yes, Your Honor. State offers State's Exhibit 1 and all attachments.
No objection, Your Honor.
All right, state, you may be excused.
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his. Sorry, just 1 second. The court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. After reviewing the same, the court will find there is sufficient evidence to find him guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. We respectfully ask that the court will go along with the agreement we have with the state.
All right, the court will sentence you to 180 days in the Bear County Jail under 1244. There's an $800 fine, time and money to run concurrent. There's to be no residing in households with minors, no unsupervised contact with minors, and the court will give you credit for any time served. How much time does he have in?
Got 90 days, but he's a trustee, Your Honor.
All right, so this is what I want to explain to you. For the court, I'm just giving you credit for any time you served. You've been in custody for 90 days. The only thing I can do is give you credit for those 90 days. Whether you're a trustee and receiving 3 for 1 or 2 for 1, that's completely up to the jail. I have no control over that. You understand?
Yes, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You have a drug problem. If you don't solve that problem, you're going to be in and out of jail or in and out of prison, or either someone's going to have to identify your body. There are plenty of places in Bear County that can help you. When you're released from custody, if you can't find a place, come back here. I'll pick up the phone and call somebody to help you. All right?
Yes, ma'am.
All right. Good luck to you.
Thank you.
You're welcome. Court is calling
Thank you,
2024. Yes. CR 0150 State versus Amanda Drummond.
Douglas Chapman from Ms. Drummond.
All right, and are you Ms. Drummond? Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Amanda Mae Drummond who's placed on deferred adjudication in 2024 CR 0150 for the offense of possession of a controlled substance, penalty group 1, 1 to 4 grams on January 13th, 2025 for a period of 6 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 4 in Bear County, Texas. The defendant, Amanda Mae Drummond, did then and there fail to report to the supervision officer as directed for the months of September, October 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
And we waive and abandon the remainders, Your Honor.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty and sentence you up to 10 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor, it's for the court to grant the state's motion, find the defendant guilty, revoke her community supervision and sentence her to 3 years in the prison.
You say 3 years?
Yes, Your Honor.
All right, is that your proposed agreement, counsel?
Sure.
Are you asking the court to follow that agreement?
Yes, ma'am. Yes, ma'am.
Are you waiving your right to appeal?
Yes.
All right. The court will follow your agreement. The court will grant the motion, find you guilty, revoke, sentence you to 3 years in the prison, give you credit for any time served. There is to be no unsupervised contact with minors and no residing in households with minors. And the court will request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes.
Because this is a plea bargaining agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
You're gonna have to start making better decisions, all right?
I've been clean for 2 years.
All right, good luck to you, okay?
Thank you.
All right, thank you.
Thank you, Judge. May I be excused?
Jesus Vigil. Thank you. All right, court is calling 2025 CR 0136676 State versus Jesus Vigil. Can I have parties announced for the record?
Lauren Espinoza for the state.
Jason Wolf for defense.
And are you Mr. Vigil?
Yes, Your Honor.
All right, off the docket for a moment. All right, we're back on the record. I'm sorry, could you all re-announce?
Lauren Espinoza for the state.
Jason Wolf for defense.
All right, and you're Mr. Vigil.
Yes, Your Honor.
All right. Counsel, have you received all discovery? Did you review it with your client?
I have you.
Court will find that the state is in compliance with discovery. Mr. Vigil, did you review the application for deferred adjudication with your attorney? Did you understand it
Yes, Your Honor.
and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Vigil, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with tampering or fabricating physical evidence with intent to impair. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, court does not have to follow it. If the court does not follow it and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor. I do.
Mr. Vigil, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 5 years in the prison. There's $1,000 fine. The state is opposed to your application for deferred adjudication. They're taking in consideration 2025 CR 014681 and 2025 CR 013676. There's restitution of $180 to DPS for lab testing. Did you understand that to be your plea?
Yes, Your Honor.
Defense?
It is, Your Honor.
State?
Yes, Judge.
Did you review the waiver appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be a TAP evaluation. There's to be no arms or ammunition. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Receipts exhibit 1 and all attachments.
I reviewed those with my client, Your Honor. We have no objections.
All right, did you review the waiver and stipulations with your attorney? Did you understand it, sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Judge, we would like a PSI since they are opposed to deferred unless the court doesn't feel it needs that to.
So do you want to
Deferred, then
proceed?
no, I'd love
Okay.
to proceed if we can.
All right. State you're opposed to the application for deferred adjudication?
Yes, Judge, we're opposed based on the underlying facts. There was a search warrant for the location. Additionally, the home that Mr. Vigil was in contained a not a large quantity, a variety of narcotics as well as firearms. Judge, he has had prior encounters with law enforcement. However, I see that he was previously on deferred for a lesson exam and that expired. So just based on his, I guess, small criminal history past, I would be opposed to allowing him deferred again, but state does recommend him for community supervision.
All right. Who is Marissa Gallardo?
That would be my wife.
All right. Do you have minors living in your household?
I do.
And what are their ages?
4 years old.
And are you employed?
Yes, ma'am.
What do you do?
I'm an electrician.
Okay. All right. I'm gonna give you a choice. These are only 2 choices. There are no other choices on the table, so don't ask for any.
Okay.
All right. 1, I find you guilty. I'll sentence you to 5 years in the prison, suspended and probated for 5 years. Or 2, I grant your application for deferred because I know that you're an electrician now. And I will grant your deferred for 8 years.
Judge, can we take window number 2? I'd say door number 2.
I agree. Door number 2.
And I think, Judge, he'll show that he'd be successful. He'll get all of this completed ahead of time. He has working 14, 15 hours. He's changed his life. He's on the better path. In fact, he had a coworker that was electrocuted just the other day, and he conducted CPR until help was able to arrive, and the guy made a recovery. So he's knows the wrongfulness of his choices. We appreciate you granting deferred, and he'll be successful, Judge.
All right, this is what the court is gonna do. Court is gonna sentence you to 8 years deferred adjudication, regular reporting. Probation, they're saying he works 14 hours. If he provides proof that that's his actual work schedule, are you all able to allow him to report by Zoom? All right, so what I'll do is I'll do 8 years deferred adjudication. I'm gonna put Zoom with an asterisk by it. And then the times that he definitely needs to report in person, then he can report in person. I know he has to report for the first time in person. After that, if you'll allow him to report by Zoom. Okay.
Fantastic. Thank you, Judge.
All right, there's going to be field visits 1 time per month for 6 months. There is taken in consideration 2025 CR 014681 and 2025 CR 013676, restitution to DPS of $180. There's to be no possession of firearms or ammunition. There's to be no firearms or ammunition in the residence. Proof of employment within 30 days. No employment as a home health care provider with minors. TAP evaluation out of custody, follow Rex. However, if TAP recommends inpatient treatment, start with supportive outpatient treatment. There is to be 120 hours of community service restitution. I'm going to order the parenting classes. Once that's completed, community service hours will be deemed satisfied. This address that there's to be no contact with, is that your home address now or no?
No, Your Honor.
No, Your Honor.
All right, there's to be no contact with the previous address that has been stated on the record. There is a $1,000 fine, and that will be probated. Probation, is there anything else? Thank you. I keep forgetting that. Regular random UAs are either the patch, and your attorney will explain to you the difference.
Yes, Your Honor.
But most importantly, one costs more than the other. Anything else, probation? State, anything else that you will request?
No, Judge.
Is there anything else you need from the court?
No, Your Honor.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, good luck to you. Stay on the right track.
Thank you.
You're
And
welcome.
I may, Your Honor, I see that you admire a bunch of flowers. I did an electric job, real close to that area right there. They have these exotic flowers. They have all these Hawaiian flowers. I think you'd love them.
I
But
do.
go and take a look.
And I see in their card, they already have a bird of paradise.
There you go, Judge.
I would love to grow a bird of paradise, but you sort of need conditions that are more tropical. But I'm going to see if I can get a greenhouse and put it in there. Someone, my mom sent me a bird of paradise once. They're just gorgeous.
They are.
Yeah.
They're
Yeah.
really nice. But yes, go take a look. I'm pretty sure you'll find a ton
Yeah.
of things.
Should I go and say, hey, I should get a discount?
Yeah,
I tell you what, you should get a discount for referring.
I should, yeah.
All right, have a good
Yes,
one.
you too.
Once you speak with probation, you're excused.
Thank you, Judge.
Yeah. Oh, wait a minute. I'm sorry. I need that back. Because oh, no, I have it here.
Did you have the dismissals?
Yes, I gave them to,
Mr. Wolf?
yes,
Thank you.
you're welcome. All right, we're taking our recess. And normally everything else, we'll have to take it up during a break during the trial. Okay. And then we'll go over our